Hello everyone, welcome back to the channel Synergy Business Advisors Noida, your trusted business mitra which deals exclusively with business related developments. Can you really stop a bank from taking your property just by calling it agricultural land? This is one of the most misunderstood legal protections under banking law, and if you get it wrong, it can cost you your entire asset. The law does provide protection. Under the SARFAESI Act, Section 31, Clause I clearly states that agricultural land is exempt from SARFAESI proceedings. On paper, this looks like a powerful shield. But in reality, courts have made it very clear this protection is not automatic. The turning point came in ITC Limited versus Blue Coast Hotels Limited, landmark 2018 judgment, where the borrower attempted to block bank auction by claiming that the secured assets were agricultural land. The expectation was simple: once labeled agricultural, SARFAESI cannot apply. But the Supreme Court refused to accept this argument at face value. Instead, the court applied the substance over form doctrine. It examined the actual nature and use of land and found that it was part of a commercial hotel and resort project. There was no agricultural activity. On that basis, the court held that mere classification or description is irrelevant if the ground reality shows commercial use. As a result, the borrower was denied protection and SARFAESI action was upheld. Now, coming to a much more recent and practical application, Satyam Educational Trust and others versus Authorized Officer, Bank of Maharashtra. This case takes the same principle and applies it in a very strict borrower focused context under SARFAESI. In Satyam, the borrower raised two defenses. First, they claimed the land was agricultural and therefore exempt. Second, they tried to invalidate the proceedings by arguing that the demand notice was defective because it did not mention the NPA classification date. These are exactly the kinds of arguments many borrowers rely on in real life disputes. But the DRAT took a firm stand. On the issue of agricultural land, it held that the burden of proof lies entirely on the borrower. It is not enough to show revenue records or make a verbal claim. The borrower must prove that agricultural operations were actively carried out at the time of mortgage and continued consistently until the legal challenge. This requirement of continuity is critical and often where most cases fail. On the second issue, the tribunal reinforced another important legal principle: technical defects do not override substantive liability. The absence of the NPA date in the deemed notice was treated as a minor irregularity, not something that could invalidate the entire recovery process. The reasoning was simple: if the default is real, procedural gaps cannot be used as an escape route. Final outcome in Satyam, the DRAT rejected all borrower arguments and upheld the bank's SARFAESI action, making it clear that neither weak evidence nor technical objections would be entertained. Now, what does all this mean for you or your clients? The message from both the Supreme Court and DRAT is absolutely consistent. You cannot rely on labels, assumptions, or last minute defenses. Whether it is claiming agricultural land or pointing out technical flaws, everything depends on credible evidence and timely legal strategy. The biggest takeaway in this case, the law protects reality, not paperwork. If your land is not genuinely used for agriculture, no amount of documentation will save it, and if you wait until enforcement begins, your options become extremely limited. This is C&IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful for you. Please subscribe to the channel for more business related videos. Thank you.